Good morning, everybody. My name is Michael Coviello. I'm the Associate General Counsel with the National Fraternal Order Police Labor Services Division. Welcome to our first ever webinar presentation. And today we will be discussing coincidence. A couple of administrative matters before we get started. There is a function that will allow you to ask questions. You can type those questions in the box provided on the right if you have your control panel or dashboard open, which will be in the right-hand side of your screen. The questions you type in, we will attempt to answer along the way, those that we can. If we have time at the end of the presentation, we will answer as many questions as possible. We don't want to go beyond the hour that we have allotted. And for those of you whose questions are not answered or addressed, it's not that we don't want to. You can send us an email. The information will be provided at the end of the presentation. Send us an email and we'll be able to answer those questions at some point in the next few days. So having said that, let's get started. For whatever reason, my screen's not advancing. Let's see. There we go. So we're going to talk about critical incidents this morning. First, we will define what a critical incident is, what to do when you're involved in the critical incident, either as a subject officer or as an FOP representative. And we'll talk about the things that you can expect to happen throughout the investigations and the difference between your rights under a criminal investigation under the Fifth Amendment, right to remain silent, right to an attorney, and other things, as opposed to your Garrity rights when you're under an administrative investigation. One of the things we want to clear is that there is definitely a difference between what your rights are in the criminal investigation versus an administrative investigation. Those tend to get confused. So, what is a critical incident? Well, the definition that I've come up with over the years is that it is any sudden incident involving a police officer that results in an immediate investigation with no advance notice to the subject officer, potentially resulting in the arrest, suspension, or termination of the officer, and includes things such as shootings, in-custody deaths, use of force, weapons, charge, car accidents, or any allegation of duty-related criminal conduct. I have, in the 13 or 14 years that I've been representing police officers, encountered just about everything that's on that list. How often do critical incidents happen? Well, the statistics aren't gathered in that way, but here's an example of the types of threats that officers face on a daily basis. And as of October 2011, the total fatalities are up 20% over 2010. Deaths from gunfire are up 24%. Traffic accidents have gone down, but the total of other causes is up by approximately 122%. So you can see where police officers are more and more engaged in incidents that result in officer fatalities, which certainly would fit with the category of critical incident. There are 4 things that you never do if you're involved in a critical incident. You have to make it clear that if you are involved in a critical incident, you are a suspect in a criminal investigation. Therefore, the 4 things that we never do is we never give a voluntary statement, we never take a polygraph, we never give blood or urine. Now this, again, is a criminal investigation. You have the right to refuse to do all of these things. And the parenthetical after number 2, see the BOR, that stands for Bill of Rights. If your state has a Bill of Rights for law enforcement officers under investigation, there may be certain restrictions or limitations with regard to taking polygraphs. Some states prohibit it outright. Other states require it under certain circumstances. But again, that would be in the administrative portion of any investigation, an internal affairs investigation. As a criminal suspect, you never give a voluntary statement, never take a polygraph, never give blood or urine. Now, there is an exception to never giving a voluntary statement. The policy statement of never giving a voluntary statement is simply that when you are under investigation, anything and everything you say can and will be used against you in any future criminal proceeding, assuming there will be one. There are some states, some areas of some states that have very aggressively prosecuted police officers for any critical incident type involvement, sending just about every case to grand jury investigations. In those situations, the last thing you want to do is have more than one statement out there, because any difference in those statements, whether it be a minor difference or even an inference of a difference, could result in greater scrutiny than would necessarily occur had there only been one statement. There are exceptions to the never give a voluntary statement rule, and in my practice, generally what I've done is, if I know the prosecutor is willing to share information with me, and there's an open and honest communication between us such that I can trust what the prosecutor is telling me, and I know that it will ultimately be in the officer's best interest to give a voluntary statement, then after consultation with the officer in discussing what the benefits and the detractors are of giving that voluntary statement, we will make a joint decision as to whether or not you should go forward and make that voluntary statement. But at a minimum, I need cooperation from the prosecutor who's telling me that the investigation is complete as far as the criminal investigation and the state attorney's office or district attorney's office is concerned. There are no unknown variables. For example, in a housing development, if there's an exchange of gunfire, there's nobody who got caught in crossfire or was hit by a stray bullet. We have all of the available witnesses have already given their statements, and the prosecutor tells me that they simply want to close the case, make a statement to the media that the shooting was justified, and the officer cooperated in the investigation, and he tells me or she tells me exactly what it is they're looking for. They give me the questions that they want answered from the officer, and then I have an opportunity to consult with my client to the subject officer before going in to give that statement. Now, in saying that, I'm not saying that I will tell the officer what to say, but I will spend a lot of time with the officer that I'm representing going through all of the details of what happened numerous times to establish at least a baseline of fact as to what happened, and then I can counsel or guide the officer in how to answer the questions in a manner that explains all the facts truthfully and does not expose the officer to any further liability. Now, I did say there were 4 things you never do. The 4th thing you never do while you're under a criminal investigation is speak to the crisis response person or team, a victim advocate, a debriefing team, or peer groups. And the reason for that is this. There is no confidentiality in those groups unless a statute particularly covers that. Lodge chaplains, for example, I think they're wonderful folks. They serve a great purpose in our organization, but unless a state statute says that any conversation you have with that person is confidential, then it's not. There are 6 states that do have statutes that create some privilege or confidentiality in some of these things. And that is very fortunate because these groups serve, these entities serve a very valuable purpose, because when you're going through a critical incident or have just gone through a traumatic event, there is a need for counseling, there is a need for advice that sometimes it goes beyond the legal advice that you're going to need, and it's very important to have this support around you. However, I will caution you that it is very important that whomever you speak with, that you have an absolute knowledge that nothing that you say can legally be repeated outside of that relationship, and the person that you're talking to cannot be subpoenaed to testify against you in either a grand jury or a criminal proceeding, and including an internal affairs investigation for that matter. It is very, very important. Ones that we know, people we know that are absolutely covered by privilege in most states are a priest or a rabbi or a pastor of your church, a counselor, psychologist or psychiatrist, and certainly a medical doctor, physician. Those people are covered by various privileges that are created by statute throughout the country. So it's very important that before you speak with anybody about the facts of your case or anything that you're going through, that you consult with your attorney first, so that you know for a fact that nothing that you say will come back and be used against you at some point in the future. When you're on scene in a critical incident, as the involved officer, there are some things that you must do. as an officer, you're still, even though you've been involved in a critical incident, you still have a law enforcement obligation. That means you must secure the scene and as much evidence as possible. We call these the public safety type questions. Are there any suspects at large? Are there any weapons that are unaccounted for? Is the public generally in danger because somebody has left the scene or because evidence is being unsecured? That type of obligation remains with the subject officer. If there are other officers who are on the scene as well, that will help, obviously, because there will be time for you to actually take a step back as a subject officer and allow the other officers to perform these functions. This will do a couple of things. It will give you an opportunity, as I said, to step back and begin to clear your head. And secondly, it will prevent any future question that the officer involved in the shooting was involved in gathering evidence which would raise an impropriety at some point down the road, especially if you have a shooting that crosses racial lines, because those will draw tremendous public scrutiny and attention from time to time, or if a juvenile is involved, is the subject of the shooting. These things, as we know, draw a lot of public scrutiny and criticism, and anytime you have an opportunity to separate yourself from the scene, that's great. If you don't, you still have to, if you don't have that opportunity, you still have to do what you need to do to preserve the scene and act as a law enforcement officer in that situation. So in all cases, the first thing you must do is notify dispatch and your command staff and contact EMS. By getting other people to the scene as quickly as possible and by being open and communicating about it will tend to create some protection for the officer. In contacting an EMS, the other benefit for that is the subject might not have expired. If they, and I'm going to speak mostly in terms of shootings because those are the most common. In the case of a shooting where a suspect has been shot, they might not have expired, and in that case, you absolutely want to make sure that you can establish that you did everything you could to perform life-saving measures, because your intent when you walked out into that situation was not to kill someone. It was to protect yourself and others from harm. The other thing you need to do is contact an FOP representative and an attorney as soon as possible, and then other than those public safety issues, remain silent. You say nothing about the facts of the case. For example, when your supervisor shows up on the scene, you take your supervisor through what happened. There was an armed robbery at the convenience store. When I showed up, the suspect took off on foot. I pursued. The suspect turned and shot at me, and that's where you stop. As soon as you get to the point where you would say, and then that's when you need to stop and talk to your attorney. And bear in mind, privileged communications. I mentioned the people and the four nevers that you don't speak to. When you contact the fraternal order police representative, you do not tell the fraternal order police representative what you did. You don't tell anybody what you did on the scene other than an attorney, unless, again, there is a state statute that gives that person or that relationship cover by privilege and makes it legally impossible for someone to question the person you're speaking to, such as a lawyer or a physician. Excuse me. The FOP rep's primary job on the scene is going to be to make sure that the subject officer is okay and that an attorney is on the way. For you FOP representatives that are out there listening, if a subject officer starts to talk to you about the facts of the case, it's your obligation to remind the subject officer not to share the facts of the case, because the last thing you want as the representative is to be subpoenaed into the state attorney's office or to a grand jury to testify against one of your members. The other thing the FOP and other uninvolved officers should do is ensure that the subject officer is physically okay. They may be physically okay, but I can assure you that they are not emotionally or mentally okay at that point. Regardless of how tough, strong, etc. that officer is or appears to be at that moment, I can tell you from experience that there is not a single officer in close to 100 critical incidents that I've been involved in that, despite what they might appear on the outside, is actually doing okay as a result of one of these critical incidents. As I mentioned before, get the subject officer in contact with an attorney as soon as possible, and then stand by with the subject officer until the representative or the attorney arrive. The reason for this is twofold. It provides tremendous support for the officer. Even though they won't necessarily admit that they need your presence or comfort, that's exactly what you are providing by standing by. You are also there as a protection to remind the officer, whenever the officer wants to start talking about the situation, not to say anything until the representative or the attorney arrives. We have a characteristic as human beings that whenever we're involved in any type of stress, most of us tend to want to talk about it, if for no other reason, just to get it out, to relieve the stress. And in some cases, people feel they have a need to justify what they've done. All you need to do at this point is remind the officer not to talk about the facts of the case. And then when the rep or the attorney shows up, provide those folks with as much information as possible. When I've been on shooting scenes as the member's attorney, I have been really privileged to be around some very sharp folks who would gather as much information as possible while all of the investigators and, in some cases, public officials are meandering around the crime scene. They're out there listening and coming back to me and telling me exactly what's going on. So I get a real feel for what the environment is in terms of the investigation and what the opinion of command staff is about what's going on. That is invaluable. So for you folks out there who are reps or who are not reps but are happen to be on a scene where a critical incident has occurred, be the eyes and the ears of the attorney and get back to the attorney and give you as much information as possible. And of course, always, always, always remind the officer to remain silent. Little things definitely mean a lot. Put the subject officer in an air-conditioned or heated car as required, but never in the back of a patrol car. Now, everybody knows that you don't put anybody in the back of a patrol car unless they're under arrest, they're a prisoner, or they're a suspect. The mental impact of being put in the back of a police car, someone who's just been involved in a shooting, is significant. On top of which, the other folks who are at the crime scene, in addition to investigators, command staff, and in some cases politicians, is you have media there. And the last thing anybody wants to see is the subject officer in a picture on the evening news, subject officer in the back of a patrol car, because of the implication that that creates. Make sure there's plenty of water and food, because sometimes these things go on for hours and the officer is not allowed to leave the scene. So make sure there's plenty of food and water. And notifying family is very important because, as I said, the media is present. There are going to be media reports, and if you live in a larger city where the news cycle never ends, there'll be regular updates throughout the incident as soon as the media gets there. So it's very important that the family be notified before a picture of the officer is broadcast on the news or news of a shooting involving a police officer is heard. But it's also very important that the officer contact his or her family, nobody else. What you want to do is put the officer on the phone with a family member so that that person can do two things. They can notify their family that they're okay and that they're going to see some stuff on the news, don't worry about it. And secondly, it's a huge comfort to the officer who's involved. I have never been involved in a critical incident investigation or representation where an officer didn't have the weight of the world come off their shoulders just by having the ability to reach out and talk to somebody in their family. It's very important that that be done. And even if the officer doesn't feel it's necessary, put them on the phone. Even if you have to dial it yourself, put them on the phone with someone in the family. Now, of course, an would be it's 3 o'clock in the morning and everybody is asleep. You don't want to create that situation necessarily. But it's a huge help to the officer, and it certainly is a relief off the family to know that their officer, their loved one is okay. Also, EMS has been called to check on the suspect, but it's also very important to have EMS check over the officer. And it says if necessary. In most cases, it would appear that it's not necessary, but I have seen an occasion people who undergo such extraordinary stress that they are not necessarily exhibiting any outward signs of the negative effects of that stress, but they may have accelerated heart rate if they already have a heart condition or any other type of medical condition that could be aggravated by the extraordinary stress that they're under. There's nothing wrong with having a paramedic come over, put a blood pressure cuff on, calm them down, maybe even give them a little oxygen. There's nothing wrong with it. In fact, it could, in some cases, cut off any intrusive questioning that's being asked by command staff who are on the scene. And another thing that's very helpful is while you're milling around waiting to leave the scene, or even if you've been released from the scene back at the station, talk about trivial matters. Talk about whatever happened in the baseball game or the football game last night, or anything that comes to mind. Anything not to talk about the particular incident is very helpful, very relaxing, and it gets people calmed down. When I get to the scene, if it hasn't already been done, I almost immediately ask command staff to be released from the scene, if not immediately, as soon as possible, but haven't been done yet, because you've just been involved in this critical incident. There may be a body laying 10 feet away, and the impact and the effect of that on the person who just pulled the trigger is significant. So you have to be able to get away from the scene as soon as possible. And once I get there and in contact with the officer, I do not ask right away what happened. That amps up the stress. I try to speak to the officer, get to know him or her. We'll talk about a couple of trivial matters, and when I feel the officer is relaxed or calmed down enough, then we'll start going through the facts of the case as that person's attorney, just so that I can get a better feel for what's going on without the added stress making it worse. There will be a chain reaction after a critical incident. The obvious one is a criminal investigation. The criminal investigation could be performed by your own agency. It could be formed out to another agency if the agency that you work for is either very small or is very sensitive to allegations of conflict of interest. I've seen it in both cases where an agency is too small or even very large, and they just feel that it'd be better for another agency to do the investigation to avoid any accusation of impropriety. The state attorney will certainly, you may call them district attorneys, the prosecutor's office will certainly conduct its investigation, and the media will conduct an investigation. Now, the media's investigation will not necessarily be a good one or be unbiased, but it's one that will be out there that you will not participate in, but you will certainly hear about. And then, of course, there's the internal investigation. The difference between the internal investigation and the criminal investigation is your participation in the internal investigation is mandatory. You have no choice. If you are ordered to answer a question, you must answer a question or forfeit your position in some cases. You can be disciplined for refusing to participate in an internal investigation. You cannot legally be disciplined for refusing to participate in a criminal investigation. And we covered the reasons why you would not give a voluntary statement earlier. You will most likely be put on paid administrative leave or internal desk duty during the pendency of the investigation. And I've seen these investigations take a week. I've seen them take 6 to 8 months. It all depends upon how significant the event is, how many officers are involved. You could potentially be subject to civil litigation, especially in a very difficult situation such as a cross-racial shooting or where a juvenile suspect is involved. There's a possible post-review if you're in this that has police officer certification or standards and training. You will potentially have your standards reviewed or your certificate reviewed based on the mere fact that you've used deadly force. Some states it's automatic, other states it is not. Coroner's inquest is something that is used to determine the cause of death. Not all jurisdictions use it. It used to be very popular. It's not used very widely anymore, but occasionally it is used. The coroner's inquest is simply where the coroner or medical examiner appears in court, questioned by the prosecutor to determine the cause of death, homicide, accidental, or suicide, of a person who has died. In some cases it's a jury, in some cases it's a judge. You can be subpoenaed to attend a coroner's inquest, but you still have the right to refuse to participate based upon Fifth Amendment rights. And if there's an ongoing criminal investigation, that may be in your better interest not to do. However, that is something that you have to consult with your attorney in terms of your level of participation. And then there are citizen review boards. Citizen review boards, generally speaking, have no subpoena power. Some of them do. They're often in communities that have had a very difficult relationship with their police departments, and it's a lot of grandstanding in many cases. These citizens review boards will potentially subpoena you to attend their question and answer, and it's usually done after the internal investigation is closed, and it's usually because they don't like the investigation, how it was concluded. If the officer isn't terminated, it seems like they have to have a citizens review board, whether it was a valid decision by the chief of police or the city manager or not. The important thing to remember about citizen review boards is even if you are subpoenaed to appear, you still have the right to refuse to participate under the Fifth Amendment. If your employer orders you to participate, you still have the right to refuse based upon your right to remain silent. You have to very carefully look at what your statutory rights are in these situations. In one state in particular, only the agency can conduct an internal investigation, so the Garrity right to be protected, we'll discuss Garrity in a moment, but the Garrity right to where you are protected, anything you say in an internal investigation cannot be used against you in a criminal proceeding, is not available unless it is the agency that is ordering you to answer the question. So therefore, if your citizens review board is not part of your employer's management organization, then you may not necessarily have Garrity, which means you cannot legally be ordered to participate. It's just something that you have to, again, before you go to a citizens review board hearing as a result of the subpoena, that you consult with the attorney and bring your attorney with you. And it's not an easy answer. It's a difficult situation, but it is best that you get as much legal advice as you possibly can before you say anything at a citizen review board, because you may not legally be required to. The homicide investigation. Now, as I said, this could be detectives from your own agency or neighboring agency, or it could be both. If you have a cross-jurisdictional pursuit, for example, where you're chasing a suspect across jurisdictional lines that results in a shooting, you could have different agencies conducting their own independent investigation about the entire case, even though the shooting might not necessarily have occurred in the agency jurisdiction that's also conducting an investigation. I was involved in a multi-jurisdictional pursuit that resulted in 4 or 5 different agencies conducting independent investigations, only one of which had the shooting investigation, but they all, because the pursuit went the wrong way up a major interstate highway, there was an investigation related to that, which was part and parcel to the entire pursuit and shooting. So just be aware that there will be potentially multiple agencies investigating the case. Now, if you have a state law enforcement agency that is also responsible for your certification, they may be conducting both a criminal investigation because of their state law enforcement capabilities, as well as the administrative investigation into your certification. So remember, though, only the state attorney can grant immunity, make a filing decision, or clear the shooting. So if a detective or your chief or an internal affairs investigator says to you, you can go ahead and speak to me, it's not a problem, we're not going to go forward, we're not going to file this case, it's a clean shooting, you know what, thanks for the reassurance, but only a prosecutor can grant you immunity or make a filing decision or clear the shooting. Just keep that in mind. Now, we're going to talk a little bit more about Garrity immunity, as I said, in a little bit, and that's a different kind of immunity. This is just talking about the criminal homicide investigation. Now, what should you do as a suspect of this homicide investigation? Well, you do what all suspects should do, and that is ask for your attorney, speak only to your attorney, and do not answer any questions without your attorney present, and do exactly what your attorney tells you to do. This is not a matter of I am talking with people I work with, these people are looking out for me, this is, you know what, that all may be true, but there is nothing wrong with remaining silent until your attorney shows up and gives you the advice and you consult with your attorney. Do not talk to anyone than your attorney as long as you are a suspect in a criminal investigation. What can you expect to happen? Well, you will be detained for many hours, unless, of course, you're injured, in which case you will be taken to a hospital. Your weapons will be seized, your uniform will probably be seized, and you will be processed, meaning photographed and swabbed for gunpowder residue, blood, or anything, just like you would be as a suspect in any other investigation. And I already mentioned paid administrative leave, and you will definitely see media reports if you're in, as I said, one of those media-savvy jurisdictions. Now, you notice that all of these things that you can expect to happen are the exact same things that would happen to someone who is a suspect in any other type of investigation. You are a suspect. Now, what will you feel? This is where this is where a lot of people will probably roll their eyes and say, "Not me." But for those of you who have been involved in a critical incident or have seen someone who's been involved in a critical incident and with them, you will know that what I'm about to go through here is essentially a fact of life. The taking of a life is the worst event in the life of any human being, regardless of how much the person prompted it, deserved it, or needed it. The fact is that being the person responsible for taking another life has an extraordinary impact on the person who takes that life. There is no exception to all of the officers I've represented, and as I said, there's been over 100 of them. Every single one of them has had some level of emotional impact from the shooting. And what you can expect is an adrenaline rush, followed by some level of exhaustion, followed by another adrenaline rush, possibly euphoria, followed by depression, followed by, and it goes on and on and on. There is a psychological theory that's called the opponent process theory. And I'm going to use my mouse here to demonstrate this. If we just look at this first line where you see my mouse being dragged across, assume that's your baseline as your ordinary, everyday mindset or emotional set. Everybody has one, and you can see it. There are people who are very hyper and active, and there are people who are very, very mellow, who don't seem to get excited by anything. So everybody's baseline is in a different place. But what the opponent process theory says is that when you're involved in something that is traumatic or exciting or whatever it may be, you go on essentially a roller coaster ride. Let's say in a shooting, there's that adrenaline rush that comes with the fight or flight response. It's an automatic anatomical response that we all have. Your excitement level or your adrenaline level takes you all the way up here. As the incident transpires and you begin to relax and come down, as they say, from that experience, your excitement or emotion level or your physical alertness starts to go away. But you don't just go back to your base, you go really low. You go actually, according to the opponent process, the same distance below the line as you did when you were above. So you come all the way up here, then you come all the way down here, then you come all the way back up here, not quite as high, then you come down a little bit more, then up a little bit more, and down a little bit more, and then you eventually straighten out and you're back to your base. In extremely traumatic events, like a life-threatening event, it has been measured that this process can take as long as 72 hours. It's usually between 48 and 72 hours when people return to a feeling of normal physical or emotional or mental stability. Why that is important is this is the time period where we lose a lot of folks. Not a lot, but if we're going to lose someone, this is the time period where we're most likely to lose someone. And what I mean by that is this. The emotional trauma of this event is so significant in this period of time, this unstable period of time, that people will resort to self-medication, whether it be alcohol, whether it be prescription drugs, any one of a number of things that people do to take their mind away from something that's happened. This is the time period when contact with support structure is extremely important. This is where we need to get folks into that rabbi, priest, or pastor, the psychologist. If you're covered by a state statute that gives you privilege, that's where you want to be talking to your support staff, your peer counseling group, or your your critical incident response team. This is the time period where this is very significant. Now, this is the problem that we have here is a lot of the folks in law enforcement are very tough, strong, brave people, and they have a very hard time acknowledging that they need help or assistance. I'm here to tell you that if you are thinking along those lines, you're walking a tightrope. You may be okay, but a lot of folks aren't. And I always bring up the example of this one young guy that I represented. He was probably 24 years old. He got into a shooting, and I explained to him that it was possible that he was going to go through this. I try to explain it to everybody so that you're prepared for it, so that they understand it. I've been through some trauma in my life and didn't understand why I was feeling the way I did. So I feel it's a tool to give to people to say, if you start to feel these things, don't worry about it. You're not crazy. You're normal. Just call me. We'll get you in touch with some resources. We can work it out. This one kid said, I feel fine. I didn't do anything wrong. Everything's fine. And every day he would call me and he would say, I know what you said, counselor, but I feel good. I feel fine. Everything's fine. I didn't do anything wrong. This went on for about 3 weeks. After about 3 weeks, he called me at 2 or 3 in the morning. He was in tears. He was crying. I can't believe I killed somebody. It took that long for the impact of what happened to hit him. And I will always be grateful for the fact that he picked up the phone to call me and talk to me about it, because we were able to put him in touch with folks that would help him get through it. And his, last I knew, he was still having a very, very good and successful career as a law enforcement officer. But I have seen folks who have not allowed themselves the resources or the help that they need, whose careers have ended because they just couldn't put the uniform on anymore. And unfortunately, I know people who have committed suicide as a result of these types of incidents because they just couldn't deal with it. And so I emphasize that in light of my earlier advice, not to talk to certain people who you are not privileged to talk or do not have a privileged relationship with, please, please seek out those folks that you can speak to who are not legally permitted to share your conversation with them and get the help you need. And you can do it in secret. That's the wonderful thing about the resources that are available to you, is nobody has to know you did it. You can go speak to anybody on a long list of resources that we can make available to you, and no one will ever have to know. The other reason why this opponent process theory that I just took you is so important is that your memory is affected by this as well. Whenever we're faced with this situation and Internal Affairs wants to do an immediate interview and get the investigation underway, we say, hey, look, give us 48 to 72 hours. We're not saying we're not going to cooperate. We're not saying that we won't honor the order to come in and cooperate, but give us 48 to 72 hours. And for those folks of you who are in management who are listening, this is very important for you to remember, because if you take that statement too close in time to the event, while the officer is still undergoing the trauma and the stress of this incident, you will not necessarily get the best possible and most thorough statement, which means that at some point in the future, if an additional statement is taken for whatever reason, or additional facts come out that are somehow not consistent with the officer doesn't mean the officer said or did anything untruthful. It just means that their memory, to the best of its ability, laboring under these emotional conditions, was not thorough. It takes a while for these things, and there are many, many research studies that have been done. There's, if you want to Google the name Alexis Artwohl, A-R-T-W-O-H-L, she is a very highly recognized, well-recognized, rather highly respected psychologist who works exclusively with police officers, and she also is affiliated with the IACP. She has done numerous studies and has numerous data available to prove exactly this, that you do not allow this process to play out over the 48 to 72 hours, you are not getting the officer at his or her best when you force them to give a statement. So in that administrative arena, again, because in criminal, we're not going to talk to you until we're ready or want to, because it's a voluntary statement on the criminal investigation. In that administrative internal affairs statement, give the officer time to recover, which psychologists and professionals, even in the IACP-sponsored studies, say is a minimum of 48 to 72 hours before you give that statement, because it just has not, the memory has not fully recovered from that life-threatening event. In this process also is the officer will begin to second-guess him or herself. Did I do the right thing? Am I a bad person? Did I kill somebody? That has a significant impact not just on the officer's emotional state, but certainly on any statement that's given. It will expose the agency to unnecessary liability if it is not handled right at this time. And of course, as we said before, the officer is going to want to talk, but this is no time to play the tough guy. Take a step back, take a deep breath, get in touch with the resources you need, talk to your attorney, listen to your attorney, talk to the psychological and emotional, even spiritual resources that are available to you, and drop the tough guy act. This is not a time to play the tough guy. You're alive, that's all that matters. We'll deal with everything in time as we need to. Don't jump the gun, don't do anything unnecessary without the proper advice and consultation. What will the FOP do? Well, this is for all you reps out there, and for those of you who are, think about it. What has the FOP always done? Well, we will ensure that you are legally protected. We're doing this for a lot of years, and I have never seen an FOP member go unprotected legally who was participating in all the available plans, and even those who weren't at times. The FOP will provide for any resources and services that you and your family need, as I just mentioned. We have a very, very extensive network of resources that are available to you that we can provide. The FOP will deal with the bureaucracy. When it comes time to deal with all that administrative stuff, as the attorney representing someone in a critical incident, I take on that burden. I stand, not I, but the FOP, we will stand with you, not just behind you or at your side, but actually physically in front of you as well when necessary. And I've done that when media have had cameras in the officer's face. I've done it with regard to over-aggressive homicide detectives. Because the FOP, if it stands for anything, it stands for the fact that we take care of our members. And that's exactly what we need to do. And if you're in a position as an FOP representative where you can't, because of political pressures or work pressures, perform this function in this way, that's fine. Just make sure that the attorney is on the scene as soon as possible and involved in the case as soon as possible. Now, internal affairs and the Bill of Rights. Again, for those of you who have come from states with bills of rights, there are, I believe at last count, there are about 18 states that have some form of a Bill of Rights. So it's important that we include the Bill of Rights in this conversation. Now, we're switching gears here. We've talked about the criminal investigation and what you do as a criminal suspect, and we've mentioned a few times about the differences with administrative internal affairs investigations. Now we're going to talk about what happens in the internal affairs investigation. An officer can, at any time, be compelled to attend or to submit to an administrative statement. When you're under orders to give a statement, you do not have the right to refuse to participate, as we already said. You can be disciplined for that. So when an officer is ordered into internal affairs to give this investigative statement, it's up to the representative or the attorney to meet with the subject officer as early as possible and get prepared. Now, as I said before, we don't tell you what to say, but we certainly can tell you how to say it, how to present your information in a way that will most protect you and be truthful and cover all of the facts. And in order to do that, the representatives need to grill the officer for every fact you can get. I have never, despite however long I've spent with an officer who's going through an investigation, never gotten every fact up front, and I've almost every time learned about facts during the actual investigation that either the officer didn't think I needed to know, didn't think was important, or didn't even consider. It's going to happen. But I still tell people, don't you decide what's important for me to know or for your representative to know. Tell them everything and let the representative and your attorney decide what is important and what they need to know. As the representative and the subject officer, you want to reread the Bill of Rights if you have one, and bring a copy of the Bill of Rights with you. If the investigator is unfamiliar with the Bill of Rights or doesn't care about the Bill of Rights, you can have it there with you and say, excuse me, detective, you are now violating section such and such of the statute that says you're not supposed to be doing what you're doing. You also want to demand to know up front the type of investigation that's being conducted. Just because you're called into internal affairs doesn't mean they're not conducting a criminal investigation. So on the record, you demand your Garrity warning, and you ask the investigator, what type of investigation are we conducting here? Is this a criminal investigation or an administrative investigation? If it's a criminal investigation, thank you very much for the invitation. We are going to observe our right to remain silent. See you later. You respectfully get up and you leave. If they won't let you leave, you just say, well, I respectfully am not saying a word because I have a right to remain silent. If they order you to give a statement, then you say, is this now an internal investigation? Because you can only order me to give a statement in an internal investigation, not in a criminal investigation. And make sure that all of this is on the record. Now, the Garrity Rule. There are very few people who don't know what Garrity is, so I'll go through this very quickly. The Garrity Rule basically comes out of a New Jersey case where officers were involved in a ticket-fixing scheme. They were ordered to give answers to the investigators' questions, and the answers were used to convict them in a criminal proceeding. They appealed to the United States Supreme Court, and the court ruled that the use of their statements violated the Fifth Amendment, that the officers were forced to choose between self-incrimination and job forfeiture, and that law enforcement officers are not relegated to a watered-down version of their constitutional rights, which means even though you're a law enforcement officer, when you're under criminal investigation, you have the absolute right to an attorney, and you have the absolute right to remain silent. The Garrity Rule requires the department or the agency to order the officer to take the questions under the threat of disciplinary action, ask questions that were specifically, directly, and narrowly related to the officer's duties or the officer's fitness for duty, and advise the officer that the answers to the questions will not be used in against the officer in a criminal proceeding. That is what the typical Garrity case looks like. If the officer refuses to answer the employer's questions, the officer may be disciplined for insubordination. Now, essential to the application of the Garrity Rule is that the employer actually orders the employee to respond to questions. Remember I said that before. If you're ordering me to answer questions, that's an internal investigation. And by the way, if they say we're ordering you to answer questions, your next question should be, are you telling me that if I do not answer these questions that I can be disciplined for insubordination up to and including termination? If they say yes, then you are covered by Garrity. Now, how does Garrity attach? Well, as we said, you get those Garrity warnings that we just covered in the last two screens, or you're threatened with the loss of employment for failure to speak. In other words, answer my question or I'm going to fire you or we're going to discipline you. That is enough in most cases to create a Garrity right. You may be facing a choice of either self-incrimination, lying, or injurious silence. So in other words, if I speak, I'm going to incriminate myself. If I speak and don't tell the truth, I can be terminated. And if I don't say anything, I can be terminated. That would be a Garrity type situation. Now, what is the scope of the immunity? A statement given under Garrity can be used for a wide variety of purposes, but it cannot be used against the officer in a criminal proceeding. In other words, they cannot prosecute you and then bring your statement in and read it to the jury or use it against you. But it can be used against you in the disciplinary process. A civil lawyer can get his or her hands on that statement and use it against you in a civil case. It can be used to prosecute other officers, and other officers' statements can be used against you. And it can also be used against other officers for disciplinary purposes. Now, they don't order you to give a statement. They don't threaten you with termination. I'm sorry, they order you to give a statement, but they don't threaten you with termination, and they don't tell you that it's a Garrity statement. Well, how do you know whether or not to give a statement? Well, in most states, it's called implied Garrity. And implied Garrity means that you subjectively believe that your failure to answer questions will result in your job loss, and that belief is objectively reasonable. It's what we call the subjective-objective test. And what it essentially means is, under the circumstances, you're confronted with a supervisor. They're telling you that you have to answer questions. They're threatening you with discipline if you don't answer questions. And anybody in your situation would objectively agree that a supervisor ordering you to answer questions and threatening you with discipline would certainly be a Garrity type situation. Then the courts will say that the statement that you gave cannot be used against you in a subsequent criminal proceeding. It looks as though the poll questions have appeared on the screen, because it doesn't look like you're seeing our screen anymore. Is there any way we can get those poll questions off? Okay, we're back. Moving on. We gotta trigger with this. Okay. Now, one of the things that you have to consider is that if you're being asked questions by somebody and you're concerned about whether or not Garrity attaches, it's got to have to be a supervisor. Supervisors are the only ones, supervisors and managers are the only ones who have the power to discipline or recommend discipline. So be careful about who you're talking to and who is, quote unquote, issuing the order. If you happen to be walking down the hallway and you bump into the chief, and the chief says, hey, I heard you were involved in a shooting last night. Are you okay? Yes, chief, I'm fine, thank you. Well, tell me what happened. That's not an order, number one. And number two, you are not necessarily in a situation that anyone would believe you were compelled to speak. So you, at that point, in order to protect yourself, you need to say, chief, my attorney says I really shouldn't talk to anybody about this unless I'm ordered to, and I haven't been asked to go to internal affairs yet, so I think it better be better for both of us if I just say I'm okay and that everything the process is underway. You might not be very popular with the chief at that moment, but you will be protecting yourself. The type of immunity that attaches under Garrity is called use and derivative use immunity. Now what that means is whatever you say cannot be used against you, nothing that's within that statement. And they also cannot use anything that they find in that statement. For example, the only way they know of a particular witness who saw the whole thing, the only way they find out about it is because you mentioned them in your statement. They cannot use that witness to prosecute you and come in and testify against you in a criminal prosecution. That's what we call use and derivative use. They cannot derive their prosecution from anything that's in there inadvertently or indirectly, rather. Transactional immunity, by contrast, is immunity that says nothing that happened in the entire transaction can be used against you at all. No matter what anybody says, nothing. You are immune from prosecution, whether you give them the evidence or not. Transactional immunity is usually only given to mob hitmen who are testifying against the boss. Now, Garrity and other evidence. Garrity is testimonial. It does not provide immunity from procedure. And in this particular case, it's on your screen, a sheriff refused to take investigators to the scene of an incident, and as a result of that, Post took his certification away. And he said, wait a minute, I had a Garrity right to refuse to take them out there. And the court said, no, you don't. Garrity applies to statements, not procedures. Similar case, or similar outcome in this case in Illinois, where a law enforcement officer was charged with DUI and aggravated assault. What he did was he chased a citizen through town. He was smashed drunk and pulled over an individual because he was a black man driving through a neighborhood that he didn't think he belonged in. And while intoxicated, held him at gunpoint until the police showed up. He told the police exactly what happened. They arrested him for suspicion of DUI and aggravated assault for pointing the firearm at the individual. And his department's internal affairs investigators showed up and threatened him with termination if he refused to take the blood alcohol test. When he went to court, he said that the blood alcohol test should be thrown out because of Garrity, and the court said no, Garrity is inapplicable because blood alcohol results are non-testimonial. Garrity applies to words only. And this case was not a law enforcement officer case, but it's an example of what happens. A termination of parental rights case, the father sought a continuance because he couldn't testify in the termination of his parental rights case because he had a criminal trial that was pending. And the court said, no, no continuance. And he said, but wait a minute, I can't testify here without screwing up my criminal case. And the court said, you either voluntarily participate in a proceeding or you choose not to. If you voluntarily choose to participate in a proceeding, whether it be a deposition, civil case, a termination of parental rights case, whatever it is, that's voluntary. You have the right to remain silent, Even if you're subpoenaed, you have the right to remain silent, not testify against yourself, or give testimony that will incriminate you in another proceeding. So the court here said there's no Garrity type immunity for voluntary participation in a civil proceeding, and no Fifth Amendment violation for denying a continuance because the father's testimony was not compelled in the civil case. But there's another case, this one, Van Gates, where she was subpoenaed. This was a corrections officer who committed battery on an inmate. She went through an internal affairs investigation. She was exonerated. She was cleared, but was sued civilly. She was ordered to appear and cooperate in the civil case, and she was subpoenaed. She testified inconsistently in the civil case than she did in IA, and the internal affairs statement was brought in against her to impeach her, and she said, you can't do that because of Garrity. The court said, no, when you lie, you don't have Garrity anymore. Then they took her and prosecuted her federally for a federal criminal charge, and she said that she had, she had a subjective belief that she had to testify in the criminal case because she was ordered to and she was subpoenaed, and the court said no. Any objective person, any reasonable person would know that they have a Fifth Amendment right not to testify against themselves. So when you went to the civil trial and lied and gave testimony, you could have said, no, I assert the Fifth Amendment, and any reasonable person would know that. So her internal affairs statement was used against her to convict her in the federal criminal case. So the Garrity immunity is not absolute. Just bear in mind from what we've said in these few cases as to how that works. Now, as a quick summary, in these situations, the first and foremost consideration would be for you to protect your life. Always defend yourself and your life and other lives, and address the legal concerns later. The last thing we want is for you to be looking over your shoulder when you should be looking straight ahead at the threat. Also, know the type of investigation, as we said. Is this a criminal investigation where I have the absolute right to remain silent and the right to an attorney, or is this an administrative or internal investigation where I have no right other than to testify or participate and I have no choice? And know and understand the rights for each. Remember, you have the Fifth Amendment for a criminal investigation, you have your Garrity and your Bill of Rights in your internal investigation. And always, always remember, in the criminal investigation, speak to no one other than your attorney while you're under that investigation. And last and not least, do not go it alone. Get the help you need when you need it, because these situations are very, very difficult to deal with, even with help. Going it alone can, in most cases, spell emotional disaster for you. That is pretty much what we have to present, and I'm sure that Rick Weissman will be proud of me that I finished within the hour that was allotted. I hope we were able to get to the questions that were typed in and asked. If not, we certainly can respond to those questions that you email to us. And thank you very much for your attendance and your participation. And we look forward to doing more of these. If you can answer those poll questions, we will continually strive to make these better, and we will cover more and more subjects in the coming months.